Hi, I'm Paula Vincent Johnson, your notary in the East. In this video, I'm going to describe two kinds of succession because people are always asking me, if a person had a will, do you have to do a succession? You want to watch this video because each succession has a very different conclusion, and just knowing the difference might make you consider having a will prepared. So when a person dies, they leave behind an estate, which is everything they owned on the day he or she died. That's property, cars, money, jewelry, clothing, household items, and it can include intellectual properties such as a person's rights in things like books, art, or music. So you are almost always doing some sort of succession, because the succession is the legal process of transferring or distributing a person's estate to the people who inherited it. So with a will or without a will, you have to do a succession. If there was a valid will, the succession is called a testate succession because there was a last will and testament. The decedent's estate will be distributed according to that will. The decedent will have chosen whom they wanted to inherit their assets after they died. The people who inherit according to a will are called legatees. The decedent also would have chosen the executor. That's the person they wanted to wrap up everything and get their assets into the hands of the people they wanted to have it. Having an executor makes things much easier, costs less money, and the succession usually can be handled much more quickly. If there is no will, then the succession is called an intestate succession. The decedent's estate will be distributed according to Louisiana law, which dictates who inherits, who comes first, who comes last, how much they get, and who will get nothing at all. The people who inherit according to the law are called heirs. Also, who inherits depends on whether the decedent was single or married, and whether or not they had children. If you want to learn exactly who inherits and under what circumstances, then watch my video on who inherits if a person dies without a will. There's a link in the description below. Now, since the decedent did not choose an executor, the family will have to apply to the court for an administrator to be named. That can slow down the process and cost more time and money, especially if the family doesn't agree on who should be in charge. There is a bit of good news though. If the decedent died without a will, the heirs may be able to use the Affidavit of Small Succession, which is a simplified succession procedure used when the decedent left no will. The value of everything he or she owned is $125,000 or less. However, the decedent's estate will still be distributed according to Louisiana law. Hiring an attorney and going to court is not necessary, though. I may be able to help you get it done. For more information about when this procedure can be used, watch my video about affidavits of small succession. I think it's worth watching the entire video so that you understand the process, and it's only about 7 minutes long. Then give me a call to schedule your free telephone conference to see how I can assist you as a notary public. Now, there are ways that a person can avoid the succession process. However, this usually involves having a living trust. Establishing a living trust is a highly technical process. If you don't do it right and stay within the guidelines for handling the trust, your family could still end up having to do a succession. If you are interested in living trust, then I strongly urge you to contact a competent attorney authorized to practice law in Louisiana and who is knowledgeable about establishing and maintaining living trusts. Additionally, any accounts that have beneficiaries, such as life insurance, annuities, payable on death accounts, do not have to go through the succession. With any account that has a beneficiary, the money will be distributed directly to that beneficiary. So to recap, a testate succession means the decedent had a will. His assets will be distributed according to his wishes. An intestate succession means the decedent did not have a will. He had no control over his estate. His assets were distributed according to Louisiana law. It is possible to avoid a succession. You can set up a trust, but you need legal advice from a competent attorney to make sure you set things up properly. You can also use accounts that have beneficiaries, such as insurance or payable on death accounts at your bank. Talk to your insurance agent or banker about these options. If you learned something and like the information that you just received, then please subscribe to this channel. Subscribing helps because it tells YouTube that you like this new channel and you want other people to find me more quickly. So the more you interact with me, the better. Also, click the thumbs up button to like this video, and don't forget to click the bell so that you can be notified when new information is available. Connect with me on Facebook and Twitter, where I give quick answers to your quick questions. And visit my website at notaryintheeast.com, where you can join my email list so that you can periodically receive exclusive news, tips, and information about all types of notarial transactions that regularly affect your life. When you connect with me, I promise you'll learn something. Thank you for watching. I appreciate you. I'm Paula Vincent Johnson, your notary in the East.